The following program is made possible in part by the Dayton Bar Association.
Good evening and welcome to You and the Law. I'm Mike Bonda, your producer and host for today's program, and what we're going to be talking about today is wage and hour discrimination. And we're honored to have as a guest a specialist in this from the Cincinnati area, Mr. Andrew Kimball, attorney at law, and we'll find out a little bit more about him in a moment. We're going to be talking about wage disputes, minimum wage problems, overtime problems, tip shaving, things like that, class actions. But before we get to our discussion, let me remind you that You and the Law is a monthly presentation produced here at the studios of the Dayton Access Television. DATV is on Channel 5, and it's the public access channel now of Spectrum Cable Network in Dayton. The program is also cablecast on tape delay via the auspices of the Miami Valley Cable Council North and South. And we do come to you live on, I believe, Channel 6 in the suburbs. So if you're watching there, fine, welcome. And we also stream live at datv.org. Executive producer for the program is the originator of the show and former domestic relations judge Mike Brigner. We are an audience participation show. We are coming to you live and in color, so when you see a number, if you have a question about our topic, please call. And the number, as you'll see pretty soon, is 223-5311. We are sponsored by the Dayton Bar Association, whose director is Bill Wheeler and has been for a number of years. I understand Bill is thinking of retiring, and if he is, maybe he should call in and ask one final question of us. So we appreciate the Bar Association. We'll talk a little bit about them as the program goes along. So without further ado, we will turn to our guest, Andrew Kimball. And Andrew, welcome. Tell us a little bit about yourself and your familiarity with wage and hour disputes.
Sure. Mike, thanks so much for having me, first of all. Thanks to your staff also. Like you said, I'm a wage and hour lawyer. I'm actually a native Daytonian, Chaminade Julienne grad, at University of Dayton grad. And I am now in Cincinnati, like you said, working for Markovitz, Stock & DeMarco. We are a boutique law firm that does some antitrust work, but also does some wage and hour, which is what I focus my practice on.
All right. Well, what is wage and hour law and Fair Labor Standards Act, things like that? Mm-hmm. What categorizes this field of law, and what type of people do you represent, and what type of relief are we trying to get for them?
Sure. Well, wage and hour law, the basis of wage and hour law is a federal law that's almost 80 years old. The Fair Labor Standards Act was passed in 1938, and it gave us two basic rights that we all consider to be just extremely straightforward and fundamental to us today, which are the right to minimum wage for hours worked and the right to overtime, in other words, time and a half, your regular rate of pay, for any hours worked over 40 in a work week.
No, go ahead.
Oh, I'm sorry. This is something that comes up in every industry. It affects all levels of employees, from middle managers, but most of my clients are minimum wage, low-income workers who are earning minimum wage or close to it, or in some cases tipped minimum wage, which is less than $8.15 an hour, which is minimum wage in Ohio.
Okay, so what sort of issues do we have in generally wage and hour disputes, and apparently there's some discrimination in it that we're talking about?
Sure. Well, discrimination is really another arm of employment law, which is something else that we also do. This addresses issues like wrongful termination, harassment, retaliation for complaining, things like that, for complaining about certain protected rights that arise under federal and state law. The Fair Labor Standards Act, like I said, is something that pops up in every single industry, and that's for two primary reasons. The first being that it affects your bottom line. Employers are trying to save on their bottom line, and one way to do that is to underpay their workers, unfortunately. So they have a very natural reason to violate the law, and that it's they get to put more money in their pocket. The second reason is that they think that they can get away with it, in which they often do get away with it. Most of the time, that's because an employee, doesn't complain about it, doesn't know his rights, and things like that. I don't mean to say that they're doing something, that is in bad faith, but oftentimes it's just a business decision that arises, and they never face a lawsuit for it, so it's not an issue for them.
Well, the bottom line and the profit motive probably generate the motivation for companies then.
Right.
All right.
So the employees that we see in these cases, usually the three main categories of claims or causes of action that we see arise. The first relates to tipped workers. I'll tell you the other two right now. The second is time shaving and pay shaving. And the third is worker misclassification. These are the three areas that we see most of our issues arise in. And a lot of times these workers don't even know that their rights are being violated.
Don't know they even have rights, probably.
Right. They don't even. So for tipped workers, this is a nationwide issue. This is something that arises all the time. And the basis is that an employer is allowed to pay their employees that get tips less than minimum wage. Federally, it's actually $2.13 per hour and has been since 1991. In the state of Ohio, you have to pay tipped workers at least $4.08 per hour. So we're talking about extremely low wage rates, and the reason the employers are allowed to pay those amounts is because their employees receive tips. So the employer doesn't get to count the tips as part of the employee's wages, but they do get to pay a lower wage rate as a result of the tips. And this results in litigation oftentimes because the employer does not comply with all of the requirements that relate to taking a tip credit from an employee's wage. So, like I said, you can take a tip credit, but you can't double dip. You're not allowed to count the tips then on the other end. So the way that they violate these rules is there's two rules under the FLSA that employers often violate. One is they have to inform their employees that they're being paid a tipped wage rate, and they have to provide the employees an explanation of the law as it surrounds tipped employees.
Now, when are they supposed to do that? Not to break in here, but are they supposed to do that at the beginning of the term of employment then?
That would seem to be the best time, the cleanest time, and that's, I think, when most employers do provide the notice and provide the information about being a tipped employee. The second and the more prevalent issue that arises for tipped employees is that they are forced into tip pools that involve people that should not be included in the tip pool.
Okay, is that where your waitress comes over and you tip your waitress $20 because she was just great, and then they have to give it to somebody else?
It could be, and there's not necessarily anything wrong with requiring that waitress to share that $20 tip with somebody else. There are valid tip pools, but those tip pools include only other tipped workers, so only other folks who are engaged in customer service. The problem arises when, say, the tipped worker has to share their tips with a manager, or with the restaurant itself, or with back-of-the-house employees like cooks or dishwashers, folks that aren't engaged in customer service. When the employer requires employees to share their tips with those folks, they've done what I call poison the well. They're not allowed to take a tip credit now. And so what the result is, the law requires them to pay the difference between $2.13 an hour and $7.25 an hour federally, or in Ohio, $4.08 an hour, and the state minimum wage, which is $8.15. They have to pay that entire amount in back wages, and often additional damages as well, because the federal and state law allow for additional damages when an employer violates this law.
Tell us what a tip credit is.
So a tip credit is what the employer is permitted to take as a result of the reality that their employees receive tips. So what it is right now it's $5.12 per hour federally. So you can, essentially what it means is, instead of paying you wages, I'm going to take notice and recognition of the fact that you're getting these tips, and so I get to take this certain amount away from your pay on account of that fact. It can't be more than $5.12, and one other thing that happens is other violations will cause it to drop even further south below $2.13 or $4.08 in Ohio, and that creates another problem as well. But so the tip credit, and this is often an issue that people struggle with, because tips are not included. Tips are not considered to come from your employer. So for that reason, the employer can't claim a credit, or can't claim that, hey, I paid you that amount of money, because that actually came from a customer. So a tip credit violation can take place where an employee walks away at the end of their shift with $200 in tips. The problem is that the employer either required them to give a piece of their tips to somebody that wasn't allowed to be in it, or in some other way violated the tip credit rules.
Okay. This might be self-evident, but who are some of the people that would be earning tips that would fall into these categories?
Most often, it's going to be waiters and waitresses, bartenders, even bussers and barbacks who are also paid a tip credit minimum wage and are included in a tip pool. Those are kind of, most of the time, are the plaintiffs in these wage and hour cases. Another large group of tipped employees who often have their rights violated are delivery drivers. Our office is representing quite a few delivery drivers at this point. In various cases around the state of Ohio and around the country, really.
Is that a common thing? Do people actually, I'm trying to think of a situation where a delivery driver, they bring the package up to you or something like that? Or
yeah, well, you know,
it's something heavy.
If you've ordered pizza delivery anytime recently, you probably know that you paid between $2.50 and $3 for a delivery fee. Right?
Okay.
But that amount does not go to the driver. Unfortunately, the drivers usually receive a flat amount in reimbursement that is often falls short of the actual amount that they're spending to drive their car. You know, they're driving certain numbers of miles. They have to maintain insurance. They have to, keep their car up to date and everything so that they can make these deliveries, and that obviously comes at a great cost to them. And our view, and the view of many drivers, is that the reimbursement amount that they receive from their employer is not enough. As a result of that, their wages drop below the minimum wage, and that implicates the FLSA, the Fair Labor Standards Act.
Okay. All right. Any more tipping here that we should be talking about, or before we move on?
Another group of tipped workers that often find themselves in litigation are exotic dancers, strippers, folks who in many circumstances are actually not classified as employees, but are classified as tenants who are renting space from their employers to dance, and therefore they're not being paid minimum wage for that time or overtime for that time, and are instead having to give part of their tips that they earn to the club itself, or the owner of the club. And our view is certainly that they are employees because they're subject to the control of the clubs, and therefore they should be paid a wage rate.
So when they're hired for these performances, I guess, what is the relationship then between the owner of the club, I guess, or the establishment, and the performers.
Well, that's kind of the entire question.
Economically, yeah.
Yeah,
okay.
that's the whole story right there. The employer wants to say that they're tenants renting space. The dancer considers themselves an employee who's entitled to Social Security contributions and you know, have all the other benefits that come with employment, that come with working a full-time job. You know, unemployment compensation if they lose their job, workers' compensation if they get injured, and minimum wage and overtime for the hours that they work.
Do the persons that get tips in these types of things, do they usually have a written contract, or is it just a you know, word of mouth type thing, or what?
Some companies put a policy down on paper. Usually it's not in the form of a contract with the employee. It's more of a company policy, an employee handbook or something like that that will govern the terms of the employment. But generally speaking, employees in Ohio are at-will employees, which means they could be terminated for any reason at any time, and that they don't really have a right to continued employment going forward. So they don't have an employment contract necessarily, but often the terms of their employment are spelled out somewhere.
Okay, so if they're at-will employees and they don't like the tip policy or some of these other things, and the employer says, well, goodbye. Are they entitled to have an action for that or a claim?
Yeah, well, if they've made a complaint about their wages, that would be considered retaliation. A complaint about wages is a protected act under the law, and any employee who takes a negative action against you as a result of that, they would be retaliating against you. In Ohio, especially Ohio, there's a minimum damages of $150 per day that an employee is retaliated against. So pretty strict penalties.
Might be more than the wages.
Yeah, it could be. Yeah, it could be.
Well, what, for our viewers that watching and may fall into these categories, what form should this notice be? I mean, do they have to tell the employer, or is there some other third-party agency they would have to notify?
Do you mean what type of complaint?
Right, if they think they're being
qualify?
discriminated, yes.
Right. So the law the law considers this a protected activity. So
Okay.
some activities, some complaints or, you know, conversations might not be considered protected activities. And that is a sort of very detailed and fact-specific question. A complaint filed in federal court, for instance, would definitely be considered
Right.
a protected activity.
Right.
A complaint where, you know, a person sort of says in vague terms, oh, I feel like my check's short, or I feel like I need more money. Maybe that's protected activity, maybe it's not. If an employee says, I think this is in violation of the law, that's going to be considered protected activity.
But does it qualify for notification if they just tell the employer, I don't think what you're doing is right, for instance?
Yeah, or do you mean, do they have to make a complaint to a third-party agency or the government?
Right.
No.
Okay.
I mean, now you might run into a problem with it being documented, right? It might turn into
Right.
a he said, she said issue, but a complaint to a manager, to an employer, is protected activity as long as it's specific and it's about an issue that is protected under the law. You're not allowed to say, you know, John is treating me differently because he's a huge Steelers fan and I'm a huge Bengals fan. That is not illegal, right? So if he retaliates against you for being a Bengals fan, unfortunately, that's just the lay of the land. That's not going to be considered illegal retaliation. It may be retaliation, but it's not illegal.
It has to have something to do with the wages, the hours, and your performance in the line of duty.
Yeah, and to take it to the other areas of employment law, or sexual harassment, you know, discrimination. You know, I was given a worse job duty than so-and-so, and I think it's because I'm over the age of 40 or I suffer from a particular disability, things like that.
Okay, so suppose somebody is dissatisfied with the way they're being treated by their employer and says, I don't like that, I should be paid more, whatever remedy they're asking for, and the employer says, you're fired.
Well,
then what?
Well, then they should certainly call a lawyer right away, but then that would be considered severe retaliation. That would result in those penalties, like I mentioned, $150 a day at the very least under Ohio law, assuming the plaintiff is able to prove that to be the case.
So in theory, that would be an actionable claim.
Absolutely, but what you'll see, Mike, is that employers are smarter than that. They are not going to tell you, hey, I'm firing you, and it's because you made that complaint to me last week. They're going to come up with another
They'll wait
reason.
till tomorrow.
Yeah, and they'll come up with another explanation, and that's all excuse me. Often why I tell my clients, you're protected from retaliation, but you don't have a shield against everything, right? You still need to do your job. You still need to comply with all of the company's policies. And if you don't and they fire you for that, well, that might not be protected, right? Because maybe they just had what the law calls a legitimate non-discriminatory reason for the termination.
Okay, but an at-will employee, in theory, can be fired for no reason, right?
Mm-hmm.
So even though there might be a reason, they can say you're fired because, your dancing isn't good enough.
You've identified this
whatever.
this is the rub with at-will employment, right?
Okay.
Everybody thinks, oh, Ohio's an at-will state, so there's nothing I can do about it. Everywhere, pretty much, is an at-will state. Ohio actually is one of the very few that's not an at-will state. There's a public policy claim that you can make that if a termination is in violation of public policy, that would be an actionable claim as well. But generally, the idea that somebody's an at-will employee is just the very first question, the very beginning of the story, because the question then becomes, were they treated differently than other people at their workplace, and why were they treated differently? So if they are fired for showing up 5 minutes late, that seems to be a legitimate non-discriminatory reason to terminate somebody. But if they are a woman and their 10 male coworkers also show up 5 minutes late and they don't get terminated, well, then that would be discriminatory. So the at-will employment doctrine doesn't apply to that situation.
Even if they fired them all?
Well, if they fired them all, well, then it wouldn't be
Then it's
discriminatory
okay.
anymore, right?
You're talking about singling somebody.
Yeah,
out.
exactly.
Okay. All right. We're going to take a very short break. We're about halfway into our program, reminding you, the viewing audience, you are watching You and the Law, and we're talking about wage and hour discrimination with our expert guest, Mr. Andrew Kimball from the firm of Markovitz, Stock
And DeMarco.
and DeMarco in Cincinnati, and they're well known for this, and we're going to get back and talk about that in a little bit. The number here is 223-5311. If you have a question about wage and hour discrimination or disputes, Andrew Kimball would be the person to talk to you about that, and he will know the answer. So let me tell you a little bit about, while we're on this break, we are sponsored by the Dayton Bar Association, which has been in effect since 1883, which was before the Fair Labor Standards Act by 40 or 50 years. And Chester A. Arthur was the president back in 1883, and a lot of our founders of our association are not. So, Dayton Bar Association has been serving our community and profession, and here's some of the things that, some of the benefits for you, the citizens of Miami Valley. We have a lawyer referral service if you do not have a lawyer. For instance, if you didn't have a wage and hour lawyer, they could probably tell you who, if you're not going to call Andrew, who you could call, and there's the numbers, 7902, 222-7902 and 222-6102. And we have a notary public service. If you desire to become a notary, there's an application and testings service. A very important project we have is Wills for Heroes, where volunteer members of our association create wills for emergency first responders, firefighters, police, EMTs. If you fall into that category and you don't have a will, sign up for it. Call the Bar Association. They'll tell you when the next event will occur, and I think there's one either this Saturday or the next Saturday. Don't quote me. They'll tell you there, but it's usually in the middle of the month. We have other community service projects. Our website is www.daybar.org, giving you reference information, guides to services and legal links, and to the courts. And we have a volunteer lawyers project, serving the disadvantaged, founded and supported by members of the association. So we're trying to do good, and we feel good about the association, and hopefully you, the public, will benefit from that. So we're going to get back and talk a little bit more about wage and hour discrimination.
And I'll chime in, Mike, to say
yes.
that the VLP is a great program at the
Tell us about more about it.
I've done some of their employment
Okay.
law clinic. Kelly and the team over there are awesome. So
Kelly Unrisi.
Yes.
Yes. Yes. Yes. A lot of people, I think, don't realize that lawyers volunteer their time for the benefit of our society. So, thank you for injecting that into our conversation. We were talking about the three classifications of folks who run into wage and hour disputes. We finished with the tip. Well, I don't know if we finished, but we talked a lot about it.
We touched on the tip. The second one is what I call time shaving, and I now call time shaving and pay shaving, because
Okay.
it's popping up that way as well. This is the death by 1,000 cuts cause of action here. This is when they shave 5 minutes, 10 minutes, 15 minutes off of your pay, either by directly deducting it from your time records, by forcing you to clock out early, by automatically taking break deductions from your pay for breaks that you didn't take. I know there's some cases recently for call center employees who have to wait 10 minutes for their computer to boot up, and some of those claims might sound like nitpicking, and some of them probably are nitpicking. But another version would be working at home, an hourly worker answering emails and working from home at night, which technology allows us to do. But it's death by 1,000 cuts, because if it happens to you once, or every week, and you lose $20, $10, $20 off of it, but it's happening to everybody else that works with you, well, that money's adding up pretty quickly over time, and it's also money that the employer's getting to keep that they have no reason or right to be able to keep.
A windfall for the employer.
All right.
Just bits and pieces from you.
And already a group that is often already being squeezed, already bearing the brunt of a lot of the changes in the workplace, and unfortunately then they get these time and pay shaving issues come up. The pay shaving version, or the pay shaving side of this issue, is the delivery drivers, right? The under reimbursement by just a little bit for every single delivery that you do. Or it often arises in the context of deductions or expenses. So I would consider the mileage that a delivery driver incurs as an expense that's for the benefit of his employer. Others are deductions, like for instance, if you're a minimum wage employee, but your employer makes you pay for your uniforms, that very well might be illegal. If they tell you you have to wear jeans, that's probably not going to be illegal because you probably have a pair of jeans. But if they tell you you have to wear this company logo T-shirt, chances are that's going to be something that they're not allowed to charge you for. Things like shoes that you wouldn't typically wear. If you're a minimum wage employee already, these deductions create a minimum wage violation because the employer has no buffer zone between minimum wage and that would protect them from this violation.
So are you saying that by law those things are prohibited, or?
Not necessarily prohibited
Okay.
in the state of Ohio. In some states they're prohibited. By law, if you make $30 an hour and you have to incur $2 in expenses during that hour, that's not going to be a minimum wage violation. But if you make $8, $10 an hour, $15 an hour, which is minimum wage in Ohio, and you have to incur even just a little bit of expenses, well then now a minimum wage violation has occurred. So that, it becomes a little bit more complicated in the context of overtime, because in the overtime context, you get time and a half your regular hourly rate. So whereas minimum wage only entitles you to minimum wage, federally that'd be $7.25 an hour, overtime entitles you to time and a half your regular rate. So the moment they deduct for something that they're not allowed to deduct for, like a uniform, well, as long as you worked over 40 hours a week, that would be considered a violation of the overtime law.
Okay. Tell us a little bit about the overtime, how that's applied, and when it would apply to an employee. Does that work for, say, pizza delivery drivers?
Sure.
And how does it work exactly?
Most employees are entitled to overtime. Some employees.
When does that start?
It starts at 40 hours a week.
Okay,
so
40 hours.
The moment you've worked 40 hours in a given week, you're entitled to time and a half your regular rate for the rest of your time. That includes if you're paid on a piece rate. If you're paid for everything that you create, if you work over 40 hours a week, you still need time and a half your regular rate, which is harder to identify when you're working on a piece rate, but still must be identified and must be paid. Hourly workers are entitled to overtime. The folks who are not entitled to overtime are people who are classified as salaried exempt workers. And that's getting into the third category of employees, which is misclassification. There's a number of types of misclassification, which basically just means you're not an employee, right? Except for salary misclassification.
Okay.
But all the other types of misclassification are you're not an employee. That's why I don't have to pay you minimum wage or overtime. So for salaried employees, that basically means you're going to be paid a certain amount every week, no matter how many hours you work.
Do you find that a lot of employers who hire these types of employees get around that by hiring more employees for less hours? Is that a problem?
No, I think that's the very purpose of the FLSA, is to spread work around.
Okay.
They set the cap at 40 so that it would incentivize employers to then go find other people to fill that time. So I think that's what it's designed for. What employers often do is they tell you at the beginning, okay, I'm going to give you $400 a week for this. And basically implied in that is no matter how many hours you work. And that is a problem. That's a problem that we see all the time, where I'll talk to somebody who got terminated and they think, okay, I've been wrongfully terminated. Maybe you haven't been wrongfully terminated, but let's talk about your wages. Oh, well, I'm salaried. Oh, well, I told him it was fine. I told him I agreed that I'm salaried. Well, you cannot waive your right to overtime under the FLSA. So the determination of whether you're properly classified as salaried is a legal determination. It's not something that you can agree to with your employer. You say, oh yeah, I accept $2 an hour. That's fine with me. That's illegal. The law won't allow you to contract around this statute.
So we're getting into a third category then of, am I wage an hour or am I salaried? Isn't that something that you would think the person would know as soon as they start the job?
They do know if they're salaried. What they don't know is that they shouldn't be salaried.
Okay.
Right? So this often happens in the
Well,
context
how do they
of
find out?
well, it depends on a myriad of circumstances, I guess.
Okay.
Sometimes they might find out from me when they call me to say, hey, I got wrongfully terminated.
Okay.
You know, and they talk to me about what their job duties are. So often, for instance, an assistant manager in a retail store, a bookstore, a drugstore, something like that. This person might be classified as salaried exempt employee, and because they're a manager.
What would the definition of that be, regardless of what we're going to get into here? In theory, what is a salaried?
A salaried employee means somebody who's going to be paid a set amount every week, no matter how many hours they work.
Okay.
Unless they call off, right? So it's going to be, no matter if you work 30 hours or if you work 60 hours, you're going to make that $600 a week or whatever it happens to be set at. And the reason the law lets employers do that, depends on the circumstances, but oftentimes it has to do with managerial control, discretion, and the amount of responsibility and discretion that goes with your job. So often an employer will classify somebody as a salaried exempt assistant manager, expect them to work 55 hours a week, but really what they're doing in those 55 hours is the work of hourly employees. They're stocking the shelves. They're checking people out at the register. But what they are is they're a set labor cost. So that's the benefit to the employer. That's why they like it, because it's predictable. But
is that an employee also, or a benefit also to the employee, that they know they're getting X amount of dollars every week, even if they put in a little more time, and usually never less?
Well, there it is. There's the issue, right? So
Right.
yes, it is. It is definitely a benefit, and it's a status that many employees want to attain.
Right.
And there's nothing wrong with that, absolutely. And it's a way to be able to predict your finances and all of that. The problem is that employers, they most of the time have classified you that way because they want you to work more than 40 hours a week, not less.
Okay.
And often you'll see the employers who take advantage of this rule will, when you work 3 days a week or you work 30 hours, well, they're going to shave a little bit off of your pay, and that becomes a question of whether they are actually paid a salary.
So in this classification, you're getting calls when people are like getting worked to death. They're not getting a raise, and they say, well, I'm doing the job of 3 people, or what this guy that's working 20 hours a week is earning.
Or when I divide my hours by the pay I receive, I'm getting the same amount as my subordinates.
Right.
Those are the types of issues. And you might recall this, viewers might recall this. A couple years ago, the Obama administration tried to increase the salaried minimum wage. The salaried minimum wage right now is $23,000 and some change. They tried to increase it to roughly $49,000. That got stalled in a Texas district court and looks like it's unlikely to ever be implemented. But that was the idea behind this law, was if these people are really managerial, if they're really middle management, then they really should probably be getting paid more money. And if we're going to expect them to work these hours, then they should be getting paid more money. And so as of now, $23,000 and change is still the salaried minimum wage, but that was the reason behind the Department of Labor's attempt to change that.
Okay. So how do you enforce that?
Well, that one is a
I
very
mean, that's for private industry, right?
What do you mean?
The salaried employee in private industry.
Well, it can be in government, it can be in any industry, but the salaried employee question is a question that is very fact intensive because it doesn't have anything to do with the way your employer has classified you. It has everything to do with
what you do.
Right.
Okay.
So like I talked about, the retail assistant manager who's stocking shelves and checking people out at the register, they're probably entitled to overtime. The store manager who's running payroll and doing inventory and spending all their time in the back of the shop and hiring and firing employees, they're probably properly classified as a salaried employee.
Well, let's talk a little bit about, okay, somebody's got one of these problems, and you can talk about all of them if you want, and they're saying there's just something that's not right about this. And my neighbor's telling me, you ought to call somebody, maybe a lawyer, and they happen to call you. What is the process that is going to be gone through to determine whether they have a case in any of these categories, and then what to do about it?
Well, the first, if they call me, they're gonna get a free confidential case evaluation,
Okay.
Which usually is gonna take anywhere from 10 to 30 minutes. And so I'll run through the basics of your employment. Usually, or oftentimes, employees are calling for any number of reasons. I will always ask various questions about the way that you're compensated, and try to explain the law and the way that the law applies to you on that phone call. The next step will really be dictated by the circumstances. Are they still current employees? Is this an individual case or potentially a class case? All those things are going to dictate our first move if we think you have a viable case.
Okay. What about the cases where somebody might have had violations, but economically it's just not feasible, or it's not even worth it for the plaintiff to go through with it?
Well, and that's one of the great aspects of the Fair Labor Standards Act.
Okay.
The Fair Labor Standards Act allows a prevailing plaintiff to recover their attorney's fees after being successful. So the plaintiff has every right to still go forward, and hopefully, if they're represented by a firm like ours, they're not going to have to incur any expenses up front. They're not going to have to pay any of the costs. They're not going to have to pay us to do anything. We can hopefully recover that on the back end after we successfully litigate their case. And the reason why it's important, and maybe this, I'm sure not every employee will look at it this way, but the way I look at the plaintiffs in my cases are they're folks that are improving, whether it's a class case or an individual case, they're folks that are improving the work circumstances for everybody that comes after them, everybody that they work with at that time. And so that has a ton of value to me and hopefully to my clients when we go forward with these cases.
So the employer then can't, say, well, he doesn't have enough money to go ahead, because they're going to get, on a successful case, they're going to get bit at the other end unless they go bankrupt, I guess, right?
Right, and so exactly, and so they have an interest, if they've actually violated the law, to resolve it quickly, because they don't want me to spend a bunch of time and energy and money on it, because that just costs more for them.
Right.
Obviously, sometimes there's just a disagreement as to whether or not there's been a violation, and in that circumstance, no doubt that there will be a fight that ensues. But oftentimes the smaller, like, I didn't get paid my last paycheck, right? I got fired. I didn't get paid my last paycheck. This is something that we see all the time. And we will represent you in that case, because we think it's very obvious that a violation has taken place, and we think that the defendant doesn't have much of a defense. A lot of times employees won't go for that and won't try to get that money. I mean, I represent minimum wage employees. To me, one full paycheck is definitely something that's worth going after if you're entitled to it.
Okay. Floor director tells us we have a call coming in, so we'll take that call right now. Good evening. You're on You and the Law.
Hi. Yes, thanks for taking my call. I'm a huge fan of the show.
Great. What's your question?
I have a question relating to it pertains to my nephew. So I spent some time over the holiday with my nephew, and he told me he just got a new job, and he's working essentially 65 hours a week. But his employer basically has him officially working, I don't know the number, 32 or something, basically some amount that's just under what would be considered full-time, so that they don't have to provide him benefits. So that just sounded wrong to me. So I didn't know, is there some way he can negotiate, is that legal? Can he negotiate to have them consider him full-time, or can he, refuse to work anything beyond those hours? And the twist to my question is that his employer is a church. So I don't even know whether churches are bound by these laws and regulations, given that I know that some of the laws are different when it comes to churches and what they're obligated to do. So I'm just wondering what I can tell him if there's any advice.
Okay, great, thanks. Andrew.
Yeah, good question. That's an interesting situation, and she's right to point out that churches are sometimes treated differently under the law. In this situation, it sounds like maybe the church issue might arise under the ACA, not the FLSA, the Affordable Care Act, because it sounds like maybe the employer is attempting to avoid some sort of responsibility to pay for benefits under the Affordable Care Act by keeping him under, I believe it's 32 hours a week. I'll say that I cannot tell you right now offhand whether that is some sort of cause of action in violation of the Affordable Care Act. I know that there are some cases that arise under the Affordable Care Act where it's considered discrimination to not offer benefits to certain people. I don't know that this would be that situation, but if he is truly working 65 hours a week and only being paid for 32 or 31, that is most definitely a problem. I think they might argue that he's a salaried employee, so his salary is supposed to cover that entire period of employment. And maybe that's true. I don't know what his job duties are, and that would probably require a little bit more of a conversation. But if he's working 65 hours, the question is really, is he properly classified as a salaried employee? And as far as what sounds like a benefits issue, I think that's a bigger issue that requires a lot more conversation and analysis than probably we can discuss right now.
But he may have a cause of action.
Absolutely. I mean,
Yeah.
it depends, again, on what we were just speaking about salaried misclassification. So what are his job duties? Is he managing folks? Does he have the authority to hire and fire people? Is his primary duty management, or is he spending most of his time in other, doing other tasks? So yeah, that is going to be, the answers to those questions will dictate whether or not he is misclassified.
Does that address your question?
Yeah, it does. I'll talk to him and see, what some of his responsibilities, but whether he's classified. Can I just ask if the ACA gets repealed or gets replaced with this other Trump Care or whatever they're calling it? Would that still would he still have a cause of action under that?
So that is a great question. I don't think anybody can answer that question, but what I would say is the discussion we had about the salary, the 32 hours versus the 65 hours, and whether he can be paid a set amount for that is completely irregardless. It's separate. It's a separate question from the ACA question and from the benefits question. The question about his wages and the time he works is going to arise under the FLSA. So it's a completely different question. It won't matter what happens with the ACA with regard to his salary.
Okay, so basically a lawyer looking into this would need a little bit more information than we're talking about.
Absolutely. Your nephew will need to have a phone call with an attorney or sit down in person with an attorney and really hash out how they're spending their day, what they're doing, what they're spending time on, how long they're spending that time. All of those questions are going to be relevant to a salary versus hourly discussion.
All right. What do you think?
Thanks. Yeah, I'll
Feel free to have him give me a call. I'm happy to talk to him.
Okay, will do. He lives in Pittsburgh, though.
Okay. Well, thank you for your call, and thank you for watching.
Thanks very much. Bye.
Bye. Okay. We're in the stretch run of our show. We got a little less than 10 minutes. So we talked a little bit about, and I know we don't have enough time to flesh it out completely, but the concept of the class action versus the individual suit. So what we've been talking about so far is probably pretty much individual actions. When would we get into a class action suit?
So I'll correct you. The tipped worker discussion, the delivery drivers, the exotic dancers, time shaving, these are all issues that apply on a class-wide basis most of the time. So for instance, let's take a tipped worker case, for example. If you are a tipped worker who's paid tipped minimum wage, in Ohio that's $4.08 an hour, and you're part of a tip pool that includes the general manager of the restaurant, right? Somebody who's management, somebody who really shouldn't be sharing in your tips at all. If that is the circumstances of your employment, chances are that's the circumstances of the employment of the waiter or waitress who's standing next to you, right? So that policy is going to be applied across the board. In those circumstances, we will bring these cases as class cases because, we think that there are power in numbers, and obviously that maximizes the employees who are going to get back wages, and we think has a true deterrent effect and has an effect of causing employers to actually change their policies instead of just buying off, one employee or two employees.
Now, does that just apply to one employer, the class, or could it be multi-employers?
Well, it's a complex question, really. The FLSA allows for individual liability, so usually we'll file the case against the company that people work for and also the owner or CEO of the company that they work for. Oftentimes, employers nowadays have multiple entities that they're functioning under, whether they be subsidiaries or just single enterprises that function sort of next to each other or in tandem with each other. So all of those folks are going to be, or entities are going to be named in the case. The question becomes an interesting one when when maybe the named plaintiff can't testify about a certain thing because they don't have personal knowledge of that. You know, I don't know what's happening to the servers that are working in Wyoming for the same company because I have never spoken to any of them. Some courts, you know, might consider that to be a case where it should be a class action. Others might break that up and just take it piecemeal, or in other words, just for the individual or a smaller group, a smaller class.
Okay, let me ask you, if a person does become a plaintiff in one of these cases, whether it's individually or as a part of a class action, what are you looking for them to be doing, and what should their responsibilities to the suit and the recovery be?
In the class context, the employee that is our client will, the biggest thing that they have to do is they have to just be available. We're going to drive the bus. We're going to guide them every step of the way. So be available. You know, if I call back within a couple of days. That's primarily the main instruction, because everything else is relatively easy. You know, provide your documents. You know, keep your documents. And then, you know, you're going to tell your story. You're going to provide the testimony that makes the case. I can't do that. You know, nobody else in our office can do that. So you will be telling your story either in the context of a deposition or just through a declaration or an affidavit that we write together. But you will have an opportunity to tell your story. And then as a class rep, you have a responsibility to all your coworkers. So we ask you to consider, when you're considering settlement, when you're considering actions to be taken in the case, to consider whether that benefits everyone and not just you. Most of the time in this case it does, right? Because more money for me is more money for everybody else, and that's a good thing. But, you know, they have to consider those things carefully, and they have agreed to, you know, evaluate the case and any settlement proposals on behalf of everyone and not just themselves.
Okay. And individually, should they be like keeping records or things like that?
Yeah, well, you know, a lot of times if
writing a diary, maybe.
Yeah, if you are at work and you think something might be coming up, some violation of the law might be taking place, but you're not sure, and you haven't talked to an attorney yet, or maybe you have and they agree that possibly there's a violation going on, I always tell people to keep a diary. Do that usually. In my preference is via personal email, obviously not company email, but personal email has a time stamp on it right when you send it. You know, it's not going anywhere. You're going to be able to find it, and you know, you can document everything that you do or that happens on a given day, whether it be related to time, whether it be related to wages that you receive, whether it be related to a harassment incident or a complaint that you've made. It's always nice to have that contemporaneous record, so 6 months down the road, when they say, oh, you're making it up, you say, well, I mean, you're still going to have to prove it and everything else, but it's nice to have documented that item for yourself. Okay.
Let's talk about, in a little bit of time left, what are some of the pitfalls employees and their employers should try to avoid?
Well, I think on both sides, a huge pitfall is communication. Employers don't communicate their expectations well enough, or they don't communicate, you know, their directives well enough, and employees don't communicate their thoughts or their opinions or their positions well enough.
Is that because they're afraid of?
It can be. It can be, or it can be because they just didn't. They assumed that their boss understood what they meant when they said X, Y, or Z. And communication is going to allow most employer-employee relationships to avoid all the rest of these troubles, right? All the escalation of the situation. Another pitfall for employees is over-reliance on your job description. We get that you have a job description, but if you tell your employer every time they ask you to do something that's not in your job description, that is eventually going to grow tiresome to your employer. The third one for employees is social media. Social media has a lot of positive elements to it. In the context of an employer-employee relationship, and specifically a litigation relating to your employment, it can be really a damning thing. If you're, for instance, disparaging your employer on social media, or disclosing confidential information on social media, or, and this is to me maybe the worst one, I'm saying, hey, I worked from this hour to this hour, and your employer shows that you actually sent 30 tweets from that hour to that hour.
The old tweeting.
That's
thing,
that's not going to go over too well. So and then on the
unless you're the president.
maybe so.
Right.
And then on the employer side, your middle managers are the gatekeepers of compliance. So assuming you have set a policy that complies with the law, which, you know, obviously you should do that first. But the next thing is to make sure that your middle managers know that it is extremely important that it be followed. And you know, try to keep your employees happy.
Okay.
It's pretty simple advice.
All right. And we don't have much time for this, but any big changes coming in this area?
Well, I think there's a lot. It's to be determined how wage and hour plays out, because we've got this new frontier of the gig economy, people who don't have permanent employment, which is really what the FLSA, I think, was designed to address, and our employment laws are really designed to address. So it'll be interesting to see how our employment laws play out in this new employer-employee relationship or worker-company relationship.
Okay. Thank you.
Thank you.
Our floor director tells us we're running out of time. You have been watching You and the Law here at DATV. We have been talking about wage and hour discrimination with our expert guest, Mr. Andrew Kimball, and would like to have him back again sometime. This is his first appearance on our show. I want to thank all the volunteers behind the scenes who have made this program possible. And a last shout out to Lily, Katie, and Everett. I've been your producer and host. I'm Mike Monda. Thank you for watching. Tune in again. Good night.